Y'all, this is incredible. This is incredible. Okay, so I was just working. Belinda and I were doing our jobs, all right? And she decided to check Twitter. Thank goodness. So here we are. Okay. I'm lcadilac. Thank you for joining us. I was really getting just ill, just sick about my career and about the justice system and, you know, the things that have been going on and all of this thug case and how disgusting it was. And then I was watching the Alec Baldwin last week and I saw the judge do what the judge should do. She had the whole hearing. She knocked Baldwin's case out. And here we go, you guys. Oh my God, this is so exciting. Okay, so this is breaking news. I just got here. We all just got this. Thugger Daily just released this. All right. No evidentiary hearing even needed. Remember when I predicted the timeline, I thought this week there'd be an evidentiary hearing, okay? So this is today at 11:26 a.m. Eastern. Yeah, Tavanda, you're right. Steele will, absolutely. So they're going to do, there's no doubt that under the reassignment, they'll be asking the new judge for bond. No doubt in my mind. And I'm guessing there will be a bond. I think the lack of bond really had to do with Glanville and his prejudice. Look, guys, I wasn't even ready. My mic's over here. Okay. I mean, seriously, we were just sitting here working. This is so exciting. This is so exciting. Krause didn't even need evidence. Let's read it, y'all. Let's read it. Here we go. Order on motions to recuse Glanville. Here we go. The case before this court to consider various motions to recuse, including Diamante Kendrick's motion to recuse, Caleb Bumpus's motion to quash and recuse, and Jeffrey Williams' motion to disqualify recuse from all further dealings. The specified facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. So basically, she's saying, I don't even need a hearing because I have the record. Okay, footnote 1. This court previously considered and denied Kendrick's motion to disqualify Fulton County Superior Court judges from ruling on recusal. All right, he's not going to be upset about that, you know. She's denied it, it's okay. All right, having considered the record, evidence, and all applicable case law, this court finds the following. All right, these are findings of facts. So this is this judge going, all right, these are things, these are now facts. Whether anyone disagrees or not, these are the facts. There's no more saying, oh, well, this may have happened this way. No, this is how it happened. Boom. These recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney's Office, alleging gang activity and associated crime. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7th. The motions to recuse all arise from the same circumstances related to state's witness, Kenneth Copeland. On June 7, 2024, the state intended to call Copeland to testify. Prior to his testimony, counsel for Copeland, Jonathan Melnick, appeared and indicated in open court that Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment right and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Glanville also advised that if asked, Glanville would jail Mr. Copeland for refusing to testify. So that was on the court record. That's on June 7th, okay? After that discussion, Copeland spoke to his attorney and indicated he would testify. Once called, Copeland was asked to specify his age, and instead of answering, he stated, "I plead the Fifth." Glanville excused the jury and then advised Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10th, at which time Glanville told Mr. Copeland they would revisit Copeland's willingness to testify. Melnick spoke to Copeland and then reiterated to court Copeland still intended to invoke his Fifth Amendment right if called as a witness. Glanville indicated that he would revisit the issue with Copeland on Monday, June 10th at 8:30, and court was adjourned for the day. On June 10th, at approximately 9:10 a.m., Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Mr. Copeland, Kayla Bumpus. The meeting took place at Judge Glanville's chambers. Counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Ms. Love told Judge Glanville that she wanted the meeting to both impress upon Mr. Copeland the risk of refusing to testify and allow Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Judge Glanville about Copeland's representation. Ms. Bumpus, Ms. Love, and Glanville also discussed the scope and effect of the state's grant of immunity. Copeland was then brought to Glanville's chambers, where he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Simone Hilton, counsel for the state, who had joined the meeting. During that time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trials of all defendants in the case, not just the 6 currently on trial. Glanville discussed the code with Copeland and his rights and responsibilities after a grant of immunity. Copeland spoke privately with his standing counsel, Ms. Bumpus, and then advised the court that he would testify. After the meeting and immediately before Mr. Copeland was brought out to testify, Defendant Williams' lawyer, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Steele and Judge Glanville, in which Glanville inquired how Steele became aware of the chambers meeting. Mr. Steele declined to reveal the source of his information, and Glanville held him in contempt, though Steele was allowed to remain in the courtroom on behalf of his client, Defendant Williams. Ultimately, Copeland did testify on June 10th and was later released from custody. The next day, Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and to show cause as to why they should not be held into contempt for disclosing information about the ex parte meeting to defense counsel. An amended show cause order was later entered, setting July 1st for an in-camera review of the transcript of the ex parte meeting. All right, guys, we've been here so far. This is all stuff we already know. Of course, presumably Krause was new to this when she was reviewing it. The first motion to recuse filed by Diamante Kendrick on June 12th. Mr. Kendrick's motion seeks to recuse Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. On June 14th, Glanville denied the motion. Glanville determined the recusal motion was timely, supported by an affidavit, and on cursory review contains assertions of fact to support the allegations of bias. However, Glanville ultimately determined that there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion. During the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration. Id. Remember, id means our last quote. On June 14th, Kayla Bumpus then filed a motion to quash the show cause order and recuse Glanville from presiding over any contempt action against Bumpus resulting from alleged disclosure of ex parte meeting. On June 17th, Jeffrey Williams filed his motion to recuse Glanville. Divorced from its hyperbole. Remember when I read Steele's motion and I was like, y'all, this is so dramatic. That's what she's saying. She's saying if you take out the dramatics, divorced from its hyperbole, Williams' motion and supplement also seek to recuse Glanville because of his involvement in the ex parte meeting, which Williams alleges improper and coercive. Williams' motion alleges both actual bias and the appearance of bias because Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer, Brian Steele, in contempt. On July 1st, the day appointed for the parties to review a redacted transcript of the ex parte meeting, Glanville announced that he was releasing the entirety of the transcript to the ex parte meeting and was taking, quote, judicial notice of and making a record regarding certain matters associated with the ex parte meeting. Most of what Glanville relayed was a collation of record evidence about the recent circumstances in the case. Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Glanville explained the court's purpose and concern in pursuing information about security and confidentiality in his chambers. Glanville advised that he had not yet instigated an investigation into surveillance footage, but had reviewed such footage for timeline and security. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Glanville maintained that no one gained a tactical advantage as a result of the nature of the meeting. But Glanville also questioned defendants' right to be present at the meeting because the issue under discussion was the state and a witness who was represented by counsel. After making this record, Glanville announced that the show cause hearing was canceled and the recusal motions filed by Williams and Bumpus were referred to for consideration by another judge in accordance with the rule. The motion to recuse were assigned to this court for consideration. Okay, here we go. Motions to recuse. Bear with me, y'all. Motion to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit, clearly stating the facts and reason for belief that bias or prejudice exists. The affidavit must be definite and specific and describe circumstances of extrajudicial conduct or statements which demonstrate bias in favor of an adverse party or prejudice towards the moving party in particular, or a systemic pattern of prejudicial conduct towards the person similarly situated in the moving party which would influence the judge and impede or prevent impartiality on that action. Bare conclusions and opinions are not legally sufficient to support the motion or warrant further proceedings. Once such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeline and legal sufficiency of the affidavit and facts. If all three criteria are met, the motion is timely, supported by affidavit, and facts alleged might warrant recusal, another judge shall be assigned to hear the motion to recuse. When considering a motion to recuse, the assigned judge should be guided by Rule 2.11 of the Code of Judicial Conduct, which provides that a judge shall disqualify themselves in any proceedings in which their impartiality might be reasonably questioned. The standard is objective, from the perspective of a reasonable, fair-minded, and impartial person, rather than the affected judge or other interested parties. If a motion to recuse satisfies the three threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. Okay, well then that answers my question as I kept saying, why hasn't Glanville responded? Where's his response? Well, here's why. He's not supposed to make a response. In Georgia, he is not to respond. A judge cannot become actively involved in presiding in evidence or argument against a motion seeking his recusal without that defense itself becoming a basis for recusal. A judge has no interest in sitting on a particular case. At most, his interest lies in protecting his own reputation. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. One reason is that if he defends himself, he becomes an adversary of the movement for recusal. This adversarial posture may create an antipathy which persists after the motion to recuse is denied. And remember, that is what Brian Steele said. Brian Steele said, hey, he responded to my motion to recusal, and therefore he's now a party, and he has to be removed. Okay, here we come. Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the case to another judge for consideration, Glanville necessarily determined that the third criteria was satisfied, that recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It's worth noting that this court agrees generally with Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have, and perhaps should have, taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. Remember, I told you another judge might say it wasn't improper. However, in his order denying Kendrick's motion and in the process of making his record on July 1st, Glanville added facts, provided context, questioned the veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is objective, dispassionate, and as non-argumentative as possible so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting his record as to the recusal issues and ruling on Kendrick's motions, Glanville evaluated and accepted the truth of his own factual allegations mandating his recusal. This court has no doubt that Glanville can and would continue presiding fairly over this matter if the recusal motions were denied, but the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Glanville from further handling this case. Based on the foregoing, this court orders that the motions to recuse are granted. The clerk of the court shall reassign this case using the court's case assignment procedure. That's it. The new judge is Judge Shakura Ingram. Shakura. S-H-U-K-U-R-A. Shakura Ingram. I-N-G-R-A-M. What'll be interesting is how quickly Judge Ingram can get this onto her docket and how busy her current docket is, and do they have the same jury? What will they tell the jury? Like, oh, hey, maybe they could just tell the jury that Glanville like coughed himself out of. You guys remember that cough? Yeah, that's why he's not here. That was mean. Okay. This is so exciting, guys. This is so exciting. I'm going to go through your comments. Sorry, I was so busy reading. Okay, so I do think Steele will file a motion to dismiss, and I know Steele is going to file a motion for bond. And I know there's going to be bond hearings right away in this new judge's court. I would be surprised if these people are denied bond, but you never know. Georgia law is kind of crazy. So, pretty wild. So, thank you everyone who is joining me here this morning, or I guess this afternoon. This afternoon, I am Lauren Cadillac. I am an attorney in Dallas, Texas. I am a real estate attorney. I do litigation. I like to follow other trials, and I started following Young Thug because of the First Amendment right issues, and I thought it was very interesting, and of course it has been a giant train wreck ever since. So now we are going to have a new judge assigned, and this new judge, I'm going to imagine, is going to be much more like the judge we saw in the Alec Baldwin case, okay? That judge was no nonsense. All right, and no nonsense. I do not think the new judge is going to appreciate Miss Love's head movements and those sort of things. So I think I know it's going to be a whole new tone. It's going to be so different as we go forward watching this trial together. It is going to be so different. It will be great because I'll get to be like, see how a real judge does things? Remember how Glanville did things? And y'all will have this perfect example of a terrible judge to like see a good judge against. So Aldous says, I think the recusal is a letdown, no mistrial, nothing stated done wrong. Yeah, I think at the end where she's like, oh, well, Glanville would still do a good job. I think that's kind of shitty. I really do. But that's okay. it is what it is. It's sometimes you don't get the exact path to the result you want, but they got the result. You think Glanville stepped down and the judge did the paperwork? Maybe. Ayana says if new judges a soror, no bueno. I don't think that's true. Judges, the bias we've seen out of Glanville is like no judge I've ever seen before, and I wouldn't expect to see that out of this new judge at all. Yeah, K-Way, it does make hella excuses for Glanville. Sunday Dollar, I think she asked him what he wanted to do, and he said, I'm done. His wife probably told him to give up. Alda says the old jury is gone. So that's kind of like what I'm wondering. How can they just move to this new judge and bring back this old jury? And certainly some of this jury has seen this stuff. Certainly at least one or two of these people has looked it up. So I'm very confused about that. I don't know. And I don't know how, they can't just start with a new jury. They would have to start the case from square one if they have to get a new jury. I'm just really not sure how they're going to have the original jury come back and not have any kind of weirdness. And especially the original jury certainly observed the tension in the courtroom between defense and prosecution. And so, you know, if I was a juror, I'd be like, is the judge gone because of something they did? You know, what happened? I don't know how that will be. Cece, I don't have any tea on Judge Ingram yet because literally I've been on this live when I found out about it. So we'll see. OG says, I think the case is too damaged. Emily says her response was cautious. He's her boss and she clearly tiptoed around him. Yeah, her response is kind of, it's not as assertive as I would have liked to seen. But, you know, when we all went through this, I told you when a judge reads this ex parte transcript, they're going to say it was okay. You know, like the logic and our feelings and like the law and the application of the law don't always line up. So I don't know. Like, I don't know. Good grief. The amount of money spent on this trial alone could have been used for trade schools. I know, Robin, it's ridiculous. All the starving children that could have eaten on just the expense of this case. It's wild. It is wild. So Woody should still have to testify. Yes, I think so. We'll see. Lorenzo says no more comfort breaks. Well, I'm sure they'll have comfort breaks, but they're not going to be hour-long comfort breaks. And, you know, I'm imagining if they have them, they'll be for 5 minutes. Yeah. Tall Glass says she didn't touch on any of the bias or corruption, and that's really because she can't. I mean, that wasn't her role. Her role is to decide if he should be recused or not. She had met the burden by when the judge responded, and so she dumped it there. And to y'all's point, that is her boss. I mean, he's up the reporting ladder to her. So it was probably the best response that we could have gotten out of a Fulton County judge. And it still got us the result we wanted. So, you know, it might not have been the language we wanted or all of the result we wanted, but man, we did get some of the result we wanted. Okay, we did. We really did. Tall Glass, I highly doubt she'll allow 700 witnesses. Last I checked, they had it down to like 155. And so, I don't know. We'll see. If Woody's still testifying, can they put the members of the... Oh, yeah. Yeah. They're sure going to do that. I would absolutely do that if I were them. Yes, Jiggy, my new camera is motion sensor. I am fancy, y'all. I am. So thanks for noticing. It's so good that I actually look horrible because I didn't know I was going to be going live today. And so I didn't put any makeup on. We'll see. Yeah, the new judge might require a limited list. Who knows? Ron, I am aware of many deaths in jail. Yes, they happen all the time. Conditionally accepted says a lot of motions on the table. I don't know what you mean, but what we're gonna see a flurry now that there's the new judge assigned. We're gonna see a flurry of motions from Steele, and certainly there are going to be bond motions. So certainly going to be a bond motions. And I don't know the bond standards in Georgia, but I would be surprised if we don't see these people bond out, really, because I feel like they were only keeping them in because Glanville was Glanville, you know. Sunday Dollar, I don't know if they can evoke Woody's immunity now. I really don't know. This is like something that does not happen very often, you know. Like usually the recusals happen before the trial begins. So this is not something we have a lot of experience with. I mean, I don't think any lawyers do. So I'm not really sure how that works. We're going to watch it unfold together. We're going to figure that out together. Okay, so this means we're definitely on for August 13th, and I posted a poll today. I tried calling Hudson Grill. They never answered. I left a voicemail. They never responded. So if y'all have any ideas about where we can meet up, I would love your ideas for our meet and greet, which is going to be the evening of August 13th. And we'll get to be in a courtroom for sure on August 13th. Probably not Glanville's, but I'm fine with that. I'm excited to go see this new judge in action. I can't wait. I'm very excited to see this judge and how she manages her courtroom. Jean says Woody shut down his YouTube. I don't know. I don't know what Woody's been doing. Lorenzo says, can the state ask Woody about his recent interviews, or is that irrelevant? They should be able to ask, but they are going to have to tell the defense right away that they plan on doing that. Conditionally accepted, I think they're going to be in a new courtroom. But I don't know, maybe not, because they had that courtroom set up for so many people. I don't know, because I think that would be weird too for the jurors. But each judge has their own courtroom already, so I don't know that she would have to go down to his or what. I don't know. I'm guessing they're going to be moving to her courtroom. That's my guess. So, Hippie, so yeah, it took a year to identify this jury, but that is because Glanville was at the helm. So I really think that that Glanville's what is the delay, is the cause of all delay. And we'll see. We'll be able to see that when we have this new judge. We'll see how fast she moves, and we'll be able to be like, oh yeah, it was actually him. Or not, you know. I don't know if she'll allow the trial to be streamed, Tracy. I would hope so. I don't see why not, but I hope so. Oh yeah, Jiggy, we don't get to meet the dog now. Well, actually, now we might be able to meet the dog because Glanville's not going to be busy, so maybe we can actually go talk to him. Since the case is starting, I don't know that the case is starting all over. I don't know that. There was no mistrial called that I know of, so I don't think they're starting over. I think they're just starting in front of a new judge. But I don't know. That's really weird. Yes, Jiggy, Glanville can and will get a subpoena from Steele to come testify. Trust. Tall Glass, there would be no reason for Steele to want to appeal it. His motion was accepted. So there's nothing to appeal, and there would be no reason to appeal. It doesn't matter the reason they took the judge off. It matters that they took him off. I think hopefully Tavonda, the case is tossed, because I don't see the new judge just being able to step in and be like, oh, okay, let's go. So I would hope there would be a new jury because I think it would be really weird to tell this jury that, you know, hey, new judge, new courtroom, but I don't know. I'm not there, and I don't know how it works over there, so I don't have your answers. As this unfolds, I will let you know. As we get the news, we will let you know. You know, I came on live right now. We got the order. I came on. So when I get the news, I definitely let y'all know. Okay. Yeah, so Tracy says they're going to have to be on point now that they don't have Glanville to do their job and babysit him anymore. And that is a very good point. I think I'm very excited. I can't wait to see this trial in front of the new judge. I can't wait to see the new judge and the new rulings and what she'll allow and what she won't allow, what she'll disallow. What about his other motions he filed? Can she just overlook those? I don't think those motions are in front of her, Tall Glass. I think those motions are for the trial court judge. So, and if the trial is being tossed, then those motions are moot. So, Tavonda says, new judge, new jury, the case will follow Alec Baldwin. I hope so. I hope so, because they followed the law on the Alec Baldwin case. That was like a judge actually following the law. It was wonderful. Jiggy says the jurors would be pissed. How did the judge get dismissed before we did? You're right about that. Okay, well, that was a lovely little break. Thank you guys for joining me. I was, like I said, mid-working, so I do need to get back to that. Aldous says, does the Steele contempt charge disappear too? That's a great question. I don't think so. I don't think this judge has that jurisdiction. I think that's with Glanville. But I don't know. I think some more motions are going to have to happen. I don't think, well, I know that nothing happens automatically with the government. So who knows? Hopefully on Friday, there will be some more motions and some more information, and I'll be able to see you guys Friday at 10 a.m. and give you a whole update on that. So thank you all for joining me. I'm Lauren Cadillac, aka OG Cadillac. This was exciting breaking news. Glanville is recused. I'm so excited. Yes, maybe we're gonna see justice. Things are coming around. There is still hope. Thank you everyone for joining us, and I will see you Friday.